On May 27th, the legal organization Steptoe submitted an amicus brief on behalf of pro bono client Elyse Dorsey in support of Blake Lively's motion to dismiss Justin Baldoni's defamation lawsuit against her. As a victim of sexual harassment and retaliation herself, Dorsey's story is especially valuable for understanding how victim-abuser dynamics map out onto Blake Lively and Justin Baldoni. Her brief also clarified something that I overlooked in the first amicus brief filed by the ERA, CWLC, and CELA. And it argues against Baldoni's challenge to the fee-shifting provision from an anti-SLAPP perspective, stressing the uneven playing field survivors have to deal with when their abusers choose to retaliate against them through the judicial system. This is part 3 in what is now becoming a series related to AB 933. You should probably check out the first video because I won't be going into things from this brief that are too similar to what was pointed out already by the ERA, CWLC, and CELA. And in this installment, I want to make it a point to refocus this discussion on sexual harassment in a professional setting, like the workplace, as well as to emphasize the point that these amicus curiae are making with their amicus brief submissions. That survivors of sexual harassment face unique barriers to exposing the truth of what they've gone through, and laws like AB 933 are necessary to protect their right to speak out. Having a clearer understanding of victim-abuser dynamics should reveal how abusers weaponize defamation lawsuits and make it clear why these need to be shut down early as an improper use of the judicial system. This week, I was in Expatriarch's weekly livestream going over the latest developments in this case, and it was brought to my attention that I overlooked a key point of AB 933. I made a very naive comment that if Baldoni wanted to file a defamation lawsuit, he should at least see through the initial claims against him in the lawsuit Lively filed at first. Expatriarch rightfully pointed out that AB 933 protects statements made even without a legal claim, as long as it is with reasonable support and without malice. This matters for Blake Lively because even if she loses on her sexual harassment claim in court, he would still not be able to file a defamation lawsuit against her. Now, why is that? Let me give you an example. Imagine you're an employee who has been harassed and you don't necessarily want to take it to court, but you find out a colleague of yours has been experiencing something similar with the person who harassed you. You may want to warn them away before things go too far. You should have a right to do that without being retaliated against in the form of expensive legal action that would expose you to an invasive discovery process. And this is actually Elyse Dorsey's story. Before I begin the summary of Dorsey's story, I want to give away the conclusion. George Mason University's exhaustive investigation into her abuser, then Professor Joshua Wright, revealed he had relationships with multiple students over the course of many years of his tenure. According to its dean, Ken Randall, he resigned rather than face a termination proceeding. It is very clear from how many of his affairs were with students that he deliberately abused his position and authority to coerce those in a position subordinate to him into sexual relationships. Elyse Dorsey was one of his victims, and there is no room for argument on that unless you want to completely ignore the investigation, this man's entire history, his own admissions, and the very state of their professor-student relationship. If you're willing to let the facts speak for themselves, I think you'll understand what I meant earlier when I said that her story makes it easy to see how the victim-abuser dynamics map out onto Blake Lively and Justin Baldoni. In 2009, 23-year-old Elyse Dorsey was a first-year law student at GMU in Virginia. Among her professors was Joshua Wright, a prominent antitrust lawyer with powerful contracts in the legal industry. Ms. Dorsey worked hard in Professor Wright's contracts class, and at the end of her first year, Professor Wright asked Ms. Dorsey to serve as one of his research assistants in antitrust. But he soon took advantage of their professional relationship to coerce her into a sexual relationship, using work as a pretense to create uncomfortable scenarios. One example cited in her brief describes a trip to California where Professor Wright had only booked one room with one bed. Miss Dorsey, who did not have the means to book another room or arrange for her return trip across the country, reluctantly agreed to share the room with Professor Wright. The brief stresses that the power imbalance was central to Dorsey's acquiescence, and that should not be downplayed. By virtue of his being her professor, there was an inherent power imbalance in their relationship. Wright's coercive tactics bear a striking resemblance to the allegations made against Baldoni. He would make his advances without warning, making it difficult for the women he pursued to challenge him in the moment. It's very clear in the there was only one bed scenario that Dorsey described. Likewise, one of Lively's complaints is that Baldoni often gave no warning before improvising intimate behavior during a scene or requesting and pressuring her into more nudity. Because they were already shooting or it was the day of, Lively would have found it difficult to shove the director, her boss, especially during filming, away. Wright and Baldoni would both go on to argue that the women's participation was consensual, but they ignored the power dynamic influencing their responses. It is acknowledged by both parties that Wright and Dorsey maintained an on and off relationship over several years. However, when he broke it off with Dorsey, he also withdrew his professional support. She lost her antitrust teaching position at GMU, she was not paid for her scholarship for months, and his law firm abruptly terminated its contract with her. He cut off all contact with her despite her efforts to reach out, after establishing a relationship in which she was dependent on him personally and professionally. This is similar to how Blake describes Baldoni's behavior when called out for his uncomfortable behavior on set. Rather than handle the criticism directly, he allegedly made dismissive comments like, "I'm not even attracted to you," or "I must have missed the HR meeting." As Lively described it during a contemporaneous discussion with another female cast member, he keeps referencing it, or disconnects entirely. He gets snippy and impatient as a director. He was so huffy after the sexy thing, I felt awful for saying something. Wright's conduct has been described as an open secret at GMU. Many were aware of his behavior, and many had privately warned other young women away. In this tweet from Wright's own lawsuit, he was known by many as the Weinstein of law, and that was fine with him until he was being held accountable for it. Eventually, multiple women would come out and speak openly about Wright using his positions and influence to proposition female students, staffers, and job applicants. Dorsey was actually not the first, but like many survivors, she was galvanized to step forward because of another woman's bravery. This phenomena of one woman encouraging another to speak out simply by telling her story is important to understanding the power of the Me Too movement and why AB 933 matters. At the Time 100 Summit and Gala, Blake Lively spoke to this power of women sharing their stories. She said that because of hearing a woman speak to her experience, instead of shutting down in fear, her mother is alive today. And it's a silent torch of womanhood that we come to know. A pact that privately we must show others how to survive, literally or spiritually. But why does that torch have to be our burden to bear in private? In 2021, Dorsey filed a Title IX complaint against Wright. Title IX is a federal law that prohibits discrimination based on sex in educational programs and activities receiving federal funding. In turn, Wright filed a Title IX complaint with GMU accusing Dorsey of sexual harassment because she yelled at him after he refused to meet with her post text message breakup. He also claims that by accusing him, a man, of sexual harassment, she was engaging in sex based discrimination. While these ridiculous accusations were dismissed, partially on account of Dorsey not being an employee of GMU, Wright then went on to file a defamation lawsuit against Dorsey and Landry, another complainant. They responded by making an anti-SLAPP counterclaim against him, pointing out that Wright failed to point to any false statements that they made. But due to the shortcomings of the Virginia anti-SLAPP statute, she was forced to go through with litigating against his retaliatory lawsuit. Before I go on further, let me first define anti-SLAPP. Anti-SLAPP stands for Anti-Strategic Lawsuits Against Public Participation. Dorsey explains in this brief how the Virginia anti-SLAPP statute failed her, which is a crucial point to her argument, as AB 933 supports California's anti-SLAPP statute and makes it stronger, allowing more protection for survivors. According to the Virginia anti-SLAPP report from the Institute of Free Speech, Virginia's anti-SLAPP statute does not have any effect on discovery proceedings, creates no burden that the respondent must meet when faced with an anti-SLAPP claim, for example, proving that they have evidence that their action is not a SLAPP lawsuit, and it contains no provisions for interlocutory appeal of an order on an anti-SLAPP motion. This means the litigation on the defamation suit would proceed without waiting for a judgment on the anti-SLAPP motion. The courts also have a broad discretion on how much reward victims would get in terms of attorney's fees and costs, but the fear of never recovering from the extensive costs of litigation means that many victims will remain silent. I now want to explore how Wright weaponized his defamation lawsuit against Dorsey and her story. There are many parallels to what Baldoni has been doing since his first lawsuit against the New York Times. In his own complaint, Wright acknowledged sleeping with at least 3 of his students. Baldoni similarly acknowledges many of Lively's allegations, and both consistently downplay the impropriety of their behavior. Wright, for example, said he met Dorsey at the university where he was a professor, but left out the key detail that she was his student. He also insisted the relationship between him and the 3 women was consensual, but given the inherent power imbalance tied to his being their professor, that simply was not the case. He also tried to drag Dorsey down to his level by noting that both he and Dorsey were aware of their marital status. He neglected to mention that Dorsey was divorcing from her spouse, but he was not. He was also not being honest with his other mistresses about that, going house hunting with Lindsay Edwards and essentially leading her on while having no actual intention of leaving his wife. Baldoni likewise says Lively was comfortable breastfeeding in front of him because she did it often, but neglects to address her claim that he did not give her breaks to do it in private. He also claims she put undue burden on the crew to deliver wardrobes to her home, but neglects to note that she was only a few months postpartum and may have had a baby that she didn't want to bring on set. The same set that later gave her baby COVID, by the way. He says she refused to meet with an intimacy coordinator, but neglects to mention that they did have a call pre production and that Lively said she would meet them once production began. Both also use their pleadings to decenter the core issues of workplace sexual harassment. Relying on misogynistic stereotypes to smear these women in the eyes of the court, they rewrite the narrative. Wright called Dorsey a scorned woman and referred to their dispute as a love triangle. Baldoni, meanwhile, tries to argue that this was a matter of creative control, presenting a narrative in his lawsuit against the New York Times that depicted him as the little guy standing up to the Hollywood elites. But he should know better than anyone that a director is the leader on set. Another similarity between Wright and Baldoni that comes right out of the Darvo handbook is weaponizing particular instances of communication to transform their victim into the abuser. They both use cherry-picked text messages to support these narratives. By decontextualizing these messages, they attempt to persuade the court and the public that they are the true victims of a woman's tantrum. Though Wright revealed angry messages from Dorsey to represent her as the angry ex, he willfully left out that he had broken up with her via text message and then cut her off completely, even from professional cooperation. Of course she was upset when he wouldn't even message her about work. Baldoni recharacterized Lively's now infamous dragon message as a threat, but we know from his voicemail that at one time he acknowledged that he'd been dismissive towards her work on the rooftop scene. He'd apologized and promised to do better, but then later weaponized her moment of vulnerability in his defamation lawsuit to discredit her claims. This active effort to decenter the original issue is why I also don't particularly care about Baldoni's complaint that Lively took over editing for his movie. When we take into consideration Lively's claims that for weeks during filming, he had been improvising intimacy, adding sex scenes, and pressuring her for more nudity, it makes sense that these circumstances in which she had been feeling harassed, humiliated, and exposed would lead her to being more interested in how the final edit turned out. Dorsey's brief aggressively calls out the true intent of retaliatory defamation lawsuits: to create legal hell for survivors. These lawsuits are not meant to clear anyone's name, but to punish survivors for daring to speak out. Wright admitted in private text messages to his friends that he filed the litigation to bankrupt his accusers, not with any expectation of winning his defamation claims. As Wright wrote to his close acquaintances, maybe defamation for fun, but not to win. And you'll be pleased to know my brief to the mediator calculated my damages from these blood-sucking harlots at a minimum of $2.5 million. He even outlined the method in those texts, saying, "Now we start to cook. Drop expensive document requests. Passing motion to dismiss means I can do that, raising the cost." And in the end, Dorsey had to settle because of the weight of the financial burden. Baldoni, meanwhile, has completely abandoned his feminist platform. Not only is he allowing his attorney to claim AB 933, one of our only Me Too laws, unconstitutional, but he has also exposed multiple women to harassment and abuse by involving them in this case: Jenny Slate, Taylor Swift, and Isabella Ferrer, the actress who played young Lily. It's clear he does not care about preserving his image, but about ruining Lively's. The motion to dismiss stage is where we are currently with Baldoni's defamation lawsuit, and these remedies must be available at the earliest stage to protect survivors from a punishing, protracted legal process. Blake Lively might be able to afford it, but if AB 933 is disregarded here, what effects will that have on low and mid-income survivors later? So let's get back to AB 933 and California law. As I mentioned earlier, Dorsey argues the damages provision is central to the strength of the California statute. AB 933, while not explicitly part of California's anti-SLAPP law, is closely related because it extends legal protections and specific privileges to survivors of sexual harassment when they communicate about their own experiences. AB 933 is thus a First Amendment protection because retaliatory lawsuits are designed to silence critical speech on matters of public importance. Thus, Mr. Baldoni's and the Wayfarer party's Noor Pennington challenge isn't just about fees, it's an improper collateral attack on anti-SLAPP generally. Dorsey goes on to make a specific argument against Baldoni's Noor Pennington challenge, claiming it takes away states' rights to set their own limits on financial consequences for wrongful litigation. While Friedman claims that AB 933 is unconstitutional in that it violates Rule 11, Dorsey disagrees because, in reality, this long-standing legislative power is critical because it allows the state to respond to emerging forms of bad faith litigation. Much like how her story demonstrates the ineffectiveness of an anti-SLAPP statute in Virginia, law in practice is different from law in theory. Without critical remedies, anti-SLAPP statutes offer only illusory protection, forcing survivors to choose between silence and financial ruin. States should reserve the right to create targeted remedies to address the abuse of the judicial process. During Ex-Patriarch stream, another chatter, Obi-Mom Kenobi, said something that really stood out to me. Presumption of innocence goes hand in hand with assumption of truth. Taking Lively's claims seriously is also a right she is entitled to, which is why all motions to dismiss have to treat the claims as true. But a preemptive defamation lawsuit, while she is pursuing a suit on the basis of her claims, undermines that right and weaponizes the legal process to do so. If you're on the side of real victims, if you want to care at all about victims, I urge you to take a step back to before Baldoni filed his lawsuit against the New York Times, his first SLAPP action in all of this. And based on what has been discussed in this 3-part series, reread that document with a focus on the real issue: sexual harassment and workplace misconduct. Remember the power imbalance at play between victims and survivors. Don't let Baldoni redefine the terms under which Lively's allegations are investigated. Try as right might to paint his relationship with his students and subordinates as consensual. I think it's a mistake to overlook the power imbalance, and hopefully most of you would agree. Now, think about various systems of social inequity in place that might affect your bias in Blake Lively's case. Think about why so many people consider Blake Lively's potentially taking over an editing room more important than her very serious allegations of sexual harassment and retaliation. If we want to be truly neutral, we would need to consider the uneven playing field an actress and her male director are already starting out on. We need to consider, with regards to a sexual harassment case, the barriers that victims face in telling their truth. We should be presuming innocent until proven guilty, while also remembering that legal filings are protected speech because there is an assumption of truth. Because by placing more importance on the former than the latter, we put the odds in favor of the perpetrators and abusers, not their victims. Thanks for listening up until now. If you have any questions, I can try to clarify them in the comments. As usual, I'll be in the Baldoni File subreddit and on Blue Sky discussing this case. Thanks to Ex-Patriarch and the wonderful community in his live streams for inspiring me to make this video. I've got him and a few other creators' videos on this case in the description as usual. I've also added a link to the press release on AB 933 when it was first passed, for those who would like another explainer but in text form. Oh, and I don't usually like to ask for favors, but I've got a song cover being released in a couple days. Since it's a birthday release, I'd appreciate it if you could give it a listen. Bye-bye for now.